Well, hello. Welcome back to another exciting edition of Coffee with Stephen. So this week's blog is entitled Infringed, and we go into a discussion on the concept of infringement. Now, most of you are probably already familiar with the famous quote that comes at the end of the Second Amendment that simply says, "The right of the people to keep and bear arms shall not be infringed." Now, that little phrase that candidly does not get anywhere near the amount of attention it should, "shall not be infringed," is critically important. In fact, it only appears in one place in the entire Constitution, and that is the Second Amendment. In other amendments, say like the First Amendment, it starts with an admonishment to Congress that says, "Congress shall make no law." But in the Second Amendment, it goes in a totally different direction and says that the rights shall not be infringed. So what is the distinction there? Well, an infringement is anything that potentially could encroach upon someone's right to keep and bear arms. This is a much more expansive category. For instance, if we were to make a law that says that areas of a particular municipality can only be used for a certain form of development, and someone wanted to put a shooting range in that community, the restriction on that, even though it wasn't spelled out in the municipal code, could be seen as being an infringement and therefore would be constitutionally invalid. There are, as we've discussed before in several blogs and videos, the concept of balancing tests. Now, candidly, a balancing test may no longer even be applicable to any form of constitutional law in a post-US v. Rahimi environment. But that notwithstanding, there's always been these sort of arcane principles that have been used by constitutional scholars to uphold the state's rights to restrict our rights. Well, I think that as this sort of Second Amendment jurisprudence continues to develop in a post-US v. or New York State Rifle and Pistol Association v. Bruin environment, a much more directed focus has to be made on this concept of infringement. And I believe that there is an inevitability that this is in fact going to take place. There's been at least one district court case where a judge has agreed with this assessment that a restriction on someone's ability to acquire firearms acts as an infringement. So look to this as being a furthering battleground as it relates to Second Amendment jurisprudence. As always, love you to comment on the blog. And of course, as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.